Good evening. This is Lauren Raysor. Welcome to Know Your Rights. This is a program in which the Law Office of Lauren Raysor will provide the community with information that will help them and help the community to actually know their rights. My topics are actually picked based upon what I'm involved in and the seriousness of how I'm involved. So I picked this topic called Divorce New York Style. It's interesting that during COVID, certain decisions were made regarding marital couples. Sometimes staying together caused them to want to get a divorce, or sometimes staying together may cause them to stay together or want to get married. But my practice has had an increase in divorce, and boy, they have become nasty. So, the topic tonight is Divorce New York Style. First of all, a couple who is living together and they're married, if they make a decision about filing for divorce, that is a major decision that has incredible financial consequences depending on who is filing and who they consider is the moneyed spouse. Divorces can be expensive if they're not worked out. If children are involved, it can be a disaster waiting to happen. If property is involved, it can also be problematic as to how to divide property. So I want to take a little time to talk about the first thing a couple will ask and come in and then say, I want a divorce. And the most important thing is to understand New York law. We have something now we didn't used to have. This happened about 5 years ago. We have no-fault divorce. No-fault divorce, we used to have grounds that you could prove. You have to prove grounds. Now you have what they call no-fault divorce. You could agree that within 6 months prior to your filing, it's irretrievable breakdown of the marriage. But in order to get the divorce, you have to have fault. And now there are other types of fault. The person that files can actually put into their summons and complaint. Cruel and inhuman treatment, that's one of them. Cruel and inhuman treatment, it's not just physical. It could be putting someone down in the marriage, cursing, talking foul to one of the spouses, either one of the spouses, those type, threatening. If there are orders of protection, that could be part of a cruel and inhuman part of the complaint. There's abandonment. That means one of the spouses left the house and didn't come back. There could be what they call constructive abandonment. What does that mean? Constructive abandonment means that you're pushed out of the house. You really don't want to leave, but because of what's going on in the house, you're technically forced to leave the house. Imprisonment, that's another reason for filing for divorce. If your spouse is in prison and not coming home anytime soon, you could file for divorce because the person is in prison. Adultery, that's another one. But adultery is a difficult one because you really have to have proof. What does that mean? You really have to have proof. Now today, there's more proof than ever. You have text messages, you have Facebook posts, you have all kinds of communication where before you used to have an investigator stand in front of someone's house and roll the cameras to see if they're having this extra marital affairs. And of course, legal separation. So for example, if you sign a document saying within a year you're going to separate and you file papers within that year, you can also get a divorce in that setting. In terms of my experience, there's two things. There's something about annulment. People ask about annulments. When can you get an annulment? Annulment is when you break a particular covenant. So, for example, if you tell the spouse that you want to have kids and then you're not able to have children, that might be grounds for annulment. But a good one is that if you're married under the pretense of getting what they call a green card, that in of itself could be why there could be an annulment. So keep that in mind regarding, that aspect of things. So those are the grounds. And they become complicated with children. I am, without giving any facts or details, I have the most controversial, head-knocking divorce that I've ever had, where the case is actually on trial. We've been on trial for about 6 to 7 or 8 days. And it is just an interesting case. So, for example, with children, what do you have to pay for when you file for a divorce? You have to pay for a summons and complaint, which is now $210. You have to pay for service of the summons and complaint. I would think that it's important that you get a process server that is a company, opposed to sometimes people get their friends. That's a good way to do it. But if they had to testify in court, that could be problematic. And the most important thing, this happened in another divorce that I had, you have to have your process server must ask the individual, were they in the military? Leaving out that question could be a problem when it comes to filing the papers. So that starts with your divorce. And then we can break down procedurally what has to happen. One, you have to have what they call a net worth statement. That is required. Oh, by the way, there are certain things you can't do. You can't move assets. So if you had money in a bank account and you're planning on getting a divorce, you can't start moving money around out of bank accounts. You can't start transferring property, out of your spouse's name or your name to other people. You can't do that once you file a divorce. That would be problematic. The judge could hold you on the carpet and actually penalize you for it. Once a divorce begins, that's when, and the person is served, that's when either both sides will determine whether they need an attorney or whether they'll work it out through what they call the stipulation of settlement. I always advise that you get an attorney no matter what you do. You must get an attorney. You may lose some of your rights if you go along with one party or another party goes along with you. They may lose their rights, certain rights you may have. So you always want to check out a matrimonial case with an attorney. But once the person is served, at that point in time, there's certain things that your lawyer has to do on your behalf, and that is file an answer on your behalf. That's when you put in your answer to the summons and complaint. So you can say cruel and inhuman, you can say adultery, you can say, so for example, they will file something with their allegations, then you will have to file your answer. Along with your answer, you also have to file, and it is required, a net worth statement. A net worth statement is about 25 pages of talking about your assets, your liabilities, and all that you own, what you pay out every month in terms of your debt, what you pay out in terms of you have to list your income. All of that has to be openly discovered on a net worth statement. So that takes time. It has to be truthful. You can't say that I've gone to the hairstylist and I spend unless, you are actually spending it. I'm spending $600 to $800 a month. That may not fly. That's a lie on the net worth statement. If you don't tell the truth on the net worth statement, that can come back to haunt you during a trial. They can bring that up, that what you've done is, because a net worth statement has to be notarized. It is a sworn statement of all of your assets, liability, what you spend per month, and all the other things that you do. He and she, I guess, and they, they have to file these net worth statements, and both sides have to do it. And what do you have to file along with net worth statements? So before you begin your divorce, now that you know from Lauren Raysor and the law office of Lauren Raysor, you know you have to file a net worth statement. So before you begin the process, you might want to look at all of your assets, look at all of your liability, because that's what you're going to have to do anyway. In addition, you have to have tax returns. You have to file at least 3 to 4 years of tax returns. You also have to file your statements of where you work, your income statements. You have to put all that there. All of your credit card statements, they may want those statements for years. You may go back years. So once you file your net worth statement and all of that is in, and now the case will begin. It's costly. I have a client right now who now understands how costly a divorce, if you don't agree, how costly it can be. So divorce lawyers are hourly, sometimes flat fees, but if they're contested divorces and divorces that go to trial, I tell you, it is absolutely can be costly. Well, this is what happens in a divorce case. You've heard of something called the moneyed spouse. The moneyed spouse means that that person, whoever has more money, could bear the burden of paying the costs of the divorce. So I have a client that makes about X amount of dollars, and her husband makes about 3 to 4 times what she makes. He may, at the end of the trial, may have to pay legal fees, may have to pay child support, may have to pay alimony. So all of that is something that you would have to look at. Who is the moneyed spouse? And it doesn't matter if it's the woman. I've had a sample cases that I can tell you that I was able to get the man alimony. The man was making $18,000, I believe is, I don't know, barber or whatever. And the woman was this executive teacher or in the administration, a supervising teacher. And he made $18,000 on his tax returns. Now, whether he made money under the table couldn't be proven. But she made over $130,000, $140,000. At the end of the day, she had to pay a certain amount of his legal fees. She had to pay alimony to him, had to give him half of her retirement, had to split up the 401k. So it doesn't matter whether it's a male or female. If she is the money spouse, she has to pay a lot of his fees. And if he is the money spouse, he is going to have to pay her fees and whatever other parts of the divorce. So those are things that you really have to know. If you're the money spouse, you have to determine whether you really want to file at this time. You also have to plan it out. If you want to wait until the children turn 18, if you can wait that long. Because if the children are small, you're going to have to pay someone is going to have to pay child support. If the children, and you're going to have to pay college. So you have to really strategize as to when you want to file. And don't have any preconceived notions that somehow you can just do this and think it's going to go smoothly and the person is going to sign and you're just going to get through it. It doesn't happen that way. So these are some of the things that you have to look out for. The biggest problem in the divorces that we have, I can give you examples of what they call, you have children. Once they're children, then the question of custody, if it is not agreed upon, then you will have a major question of custody, and that can cost a fortune. What will happen is the judge will appoint a law guardian, AFC, who, I'm telling you, I laugh because the AFCs oftentimes have their own opinion about your child. And sometimes the opinion is not the opinion that you have about your child. The AFC will make a recommendation to the judge as to who has custody in your case. So you have to determine whether you're either going to have some sort of agreement with your spouse, or at the end of the day, as the court says, you're going to let me make the judge have a say in how your children are going to be raised. But sometimes that doesn't stop people from bludgeoning each other during the course of the case. So we have to continue to strategize as to when you file. So the next part of the divorce is called equitable, and I know you heard this term called equitable distribution. And these may not fit your circumstances, but this is an outline of what you have to look at. So what is equitable distribution? That is the property, that is the bank accounts, that is all of the assets. I mean, we even have situations where spouse buys gold coins. That's part of equitable distribution that has to be split among the spouse. What's left out of equitable distribution, and where the arguments sometimes come in, is inheritances are not part of an equitable distribution. So if your mother leaves, if your mother happens to leave you something, and I tell you, this weather is a little hot in here, and every time I talk about divorces, I guess I start sweating. But the point that I'm making is that with equitable distribution, those are the some of the things you have to look out for. So, did your spouse have this property before you were married? If they did, this may not be part of equitable distribution. So if your spouse bought a house prior to marriage, that may not be part of what you get as part of the equitable distribution. But there are exceptions to that. If what you did after the marriage, if what you did is you helped the value increase, you may be entitled to a portion of that you helped to increase the value of the property. The same thing with if there is, for example, a 401k, and someone comes into the marriage with a 401k. Prior to the marriage, you will not be entitled to that 401k. So don't think that once you get married and somebody has $300,000, $200,000 in the 401k, you get it. No, you don't. You have to, what you are entitled to is the 401k that was growing after the marriage. That's what would be subject to equitable distribution. Bank accounts. If you have property that you bought during the marriage, like a vacation home during a marriage, you gotta, I have one client arguing that what he had in his property was what his dad left him. And we argued that that's not true. This was not you were not part of the will. Even though your family gave it to you, our position was you purchased it. It was not left to you based upon a will. Therefore, it was not an inheritance. Therefore, our argument is that you are entitled to a portion of that property. Rental property, timeshares. The biggest thing that I've seen people is arguing over timeshares. That's what I tell people. It's funny. I tell people when you go on a romantic vacation, that's where everyone buys timeshares. Just think about it carefully, because at the end of the day, somebody, if you break up, somebody's going to want the timeshare. And I have a lot of couples who at the end of the day argue over timeshares. How about property, furniture, jewelry, that's not personal. I even had a client who wanted the wedding ring back. All of that, he can't get that back. But all of that is part of equitable. So it's your furniture in your house. Cars are part of equitable distribution. Technically, if you have a car and two spouses have cars, they can be sold, add up the money, and then split. Most of the time, the folks will say, you can have a car, you can have a car. Oftentimes, they'll leave the furniture, and for example, I have a client or potential individual that I looked into. They pretty much wanted tools, and the other spouse wanted the furniture. So they were able to split up. Somebody wanted a lawnmower, and the other spouse wanted the couch and the furniture that was in the place. So all of that you can look at as part of equitable distribution. Again, bank accounts that you share. But there's a negative part of equitable distribution. The happy part is when you're sharing what property is, but you also share debt. That's a big one. So if you have credit card debt and it's in both of your names during the marriage, that is also something that gets deducted from your equitable distribution. So if you ran up a credit card debt of $80,000 and $90,000, $45,000 and $45,000 gets deducted from your share of equitable distribution. In addition to that, the big issue with divorce, New York style, is this issue of custody. That is a incredible situation because men want custody. There are many divorces where the men want custody. So it's not something that women can automatically, like back in the day, you might think the children go with the mother, but husbands are fighting for joint custody. They're fighting to stay in their child's life. So that becomes a very big issue because oftentimes one spouse wants to make all of the decisions and then the other spouse wants to make all of the decisions. And then the court has to make a decision about whether it's joint or whether the mother has to have full custody or the father has full custody. But don't take it for granted that the father will not get custody or will not get joint custody. The way it's going today, joint custody is unless there's danger, violence at some level, it's a great possibility that with the children, there is going to be joint custody, which means that you have to share in the decision making. And part of, you get lawyers who make a lot of money off matrimonial. And the more the couple fights, I have a case right now I'm involved. It's over 3 to 4 years in a matrimonial matter. The fighting continues, and the fees that the lawyer has gotten, I would say maybe over $80,000, $90,000, $100,000 possibly before this case is over. I say that because you must think about whether, and that's one spouse's lawyer, then the other spouse, and then what else do you have to pay for? You have to pay for that law guardian, hourly rate, who's an attorney for your child. You also have to pay for forensic reports. The judge doesn't know how to make a decision, so they're going to make you pay for forensic doctor or forensic psychologist. What does that mean? That person may cost somewhere up to $15,000 or $20,000. Let's see. Someone's calling. I have to turn that off. I thought I did. If I was in court, they would tell me to turn it off. So, and the fascinating thing that they're also doing now is that a lot of the cases are by the internet. So you can go to trial now. All the court appearances are virtual at this point in time. But so those are some of the tricks of the trade with divorcing New York style, custody becomes quite expensive. It's important to also note that with custody, the judge may have to interview your child, and your child may say that what he or she wants to do. And therefore, once the child says what they want to do, that will weigh heavily on what the court does. But it's a tough thing. The family, it's excruciating. And these are the things that when you divorce in New York style, it is a major. And I just want to say, with the time that I have left here, we can continue to talk about the issue of custody. And you can't coach your children. The judge will pull you on the carpet. You can't discuss with your child what goes on in court. And the child's opinion, depending on, and I want to be clear, there is a racial tone to all of this. And if you get involved in the system, there are people who don't understand how folks of color may have a different view on children, but the people that are mostly making your decision may not be. So you have to, the family has to talk it out before they begin the battle, and prayerfully, come up with a solution where your child doesn't have to be dragged into court. And it gets ugly, and I'll use an example where I had one case in which the mother was accusing the grandparents of sexual misconduct. It gets ugly to keep the grandparents away, her husband's grandparents, away from her children. You have family members calling CPS for whatever reason to investigate, one side or the other. So it can, depending on the divorce and who the parties are, it can be damaging for a lifetime on your children and even yourself. So think about it. Try to come to grips with the realities that if you do something like a contested divorce and you don't work it out, it can have a detrimental effect on your family, your children, from days to come. This is Lauren Raysor. If you have any questions, I guess you can ask them. And this is Know Your Rights. I will see you next month.